when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation of the state government was required.
Yes.
Because they were specified in black and white in the IOA.
Correct. But
matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
And unsurprisingly, they reserved the power in the president instead of driving on to Article 368. They reserved the power in the president to disapply this entire. It's a very unusual provision, Manoj. There is no other equivalent. The executive, president is executive government, where the executive government can disapply a provision of the constitution. This was meant to operate much beyond the Constituent Assembly also, because that concurrence would continue forever. There would always be a state government. But state government, what that state government is another matter. There would always be a state government. But disapplying 370 was carved out and put in 3. Now that can't be a provision limited in time to the existence of the Constituent Assembly. And that is what explains perhaps why the recommendation rather than concurrence.
Mr. Salve, your voice was cracking just a little bit, when you were making this, the last part of your argument.
Yes.
Maybe
I'll repeat it, Bharat. Disapplying 370 itself comes under sub-article 3.
Right.
And that is why perhaps the framers of the Constitution scaled it down to recommendation instead of concurrence. And that to put it in a proviso that when there is a Constituent Assembly, during the life of the Constituent Assembly, if you decide to modify 370 or disapply 370, because the whole purpose of the Constituent Assembly was to work, to try and find this area of accommodating both.
So if I now, Mr. Salve, we got your point.
Yeah.
That's all. This is a proviso.
Yes.
So it uses the word recommendation, and it does say if there is a recommendation. We got that point. We got that line of argument.
I was just closing it by saying,
you're making just a little while ago.
Yes.
Was that you began by saying that B1 requires consultation. Matters in the list other than those covered by the IOA requires concurrence. That is B2. Then we went to D.
Yes.
He says, subject to such exceptions and modifications as the President may order by order specified.
Yes.
There is a bifurcation.
Yes.
Matters which refer to the instrument of accession require consultation. Other matters other than those governed by the instrument of accession require concurrence.
Correct. Now the point which I was making, perhaps that got lost.
We wanted you to just come back.
Yes. So again, Manoj, why this subtlety of instrument of accession being consultation and other than instrument of accession being concurrence, the significance should not be missed. Where it comes to instruments of accession and terms of accession, the last word is with the union.
No, where do you say that? How do you say that?
Because, Manoj, instrument of accession requires consultation, not concurrence. The first proviso.
Subjects are so important. Concealance.
Why this dichotomy in the first and second proviso, Manoj? You also would have to reflect over. And that also, Malad, feeds into my point, therefore, that where it comes to disapplying the 370 completely, because the whole idea of 370 was accommodating the political compromise in the accession.
Mr. Salve,
Yes.
Clause B of 371B
Yes.
does not relate to the power to make adaptations, modifications, or exceptions at all.
Yes.
What 371B says is that of all the items in the three lists, the president, the power of parliament to make laws would be limited by specific matter.
Yes.
So you take the matters in the list as they are, and then you define what would be the domain of parliament to make the law. There is no power to make exceptions or modifications in clause B at all.
No. Not at all.
Bifurcation, you correctly said that there was a bifurcation. Matters which are referable to the instrument of accession are those on which you only require consultation, because these matters clearly specified in the IOA: defense,
Correct.
foreign affairs, communication. Therefore, when Parliament specified the matters on which it would make laws, if those matters were referred to in the IOA, only consultation of the state government was required.
Yes.
Because they were specified in black and white in the IOA.
Correct. But
Matters which were not specified in the IOA but are governed by the three lists, concurrence is required.
and Malad,
Now, when it comes to
yes.
D is not just specification of matters. D is making exceptions or modifications.
That's right.
There again, they had a dichotomy. You can make exceptions or modifications, but if it relates to matters in the IOA,
Consultation.
only consultation. So you are really right that insofar as D is concerned, in regard to matters which are specified in the IOA, only consultation is required.
And Malad, one cannot miss the significance, what I wanted to add, of the overlay of the principle of international law, which is engrafted in 363. That these are matters primarily for the sovereign. Instruments of accession and their interpretation has always been a matter for the sovereign. And here the accession being complete, irrevocable and irreversible. That is clear. 1 and 3, Article 1 and 3. Where it touched the instrument of accession, the president had the last word. And that philosophy is reflected in some article. That if you want to completely disapply this political arrangement, if there is a Constituent Assembly, consult them, otherwise you can do it. And there also recommendation.
In other words, Mr. Salve, what you're trying to drive at is that clause 3 of Article 370
Yes.
is absolutely on the same is on the same
Philosophy.
or is the same platform
Yes.
as clause B1 and the first proviso to D. You're trying to equate the power and the substantive part of clause 3.
The underpinning is the same, Manoj.
Or
The underpinning is the same.
the first proviso to D and B1.
Yes. And because the underpinning is, this is where we accommodated, or this is where the powers that be, when framing the constitution, accommodated the political compromise in Kashmir. And unsurprisingly, they reserved the power in the president, instead of driving on to Article 368, they reserved the power in the president to disapply this entire. It's a very unusual provision, my lord. There is no other equivalent. The executive, president is executive government, where the executive government can disapply a provision of the constitution.
Only